I bet to mention item number 7 and 8.
Yes.
This is also connected with item 12. Just having been spot there, this was that matter regarding
Yes, yes.
criminal transport inspector. Lordship, on the earlier occasion, it had fallen from the Lordship. We exchanged our pleadings so as to see whether it is connected or not. If I may pray, Lordship, their petition we have got it by way of certified copy. Kindly have the matter next week, and next time we exchange the pleadings. If it is found to be connected, Lordship, it has to be wait.
Or for the decision of the Supreme Court.
If it is found that it is not connected, then possibly the matter can be heard, Lordship, as far as item 12 is concerned. So next week, Lordship, 7, 8 and 12.
On pre-made by the parties. This is matter after 1 week.
Pleasure.
May it please, Your Lordship.
Yes.
Lordship, if I can make a mention of item number 11.
Yes, Mr. Nindal, tell me.
Lordship, item number 11, if this matter could kindly be taken after a week, my lord. I require some instructions in this matter. Item 11.
Lordship, I have filed the affidavit, Lordship, in this matter. In terms of the last order, I filed the affidavit.
So state has filed the affidavit. I require some instructions in that affidavit.
This is with regard to the advertisement
Yes,
Yes,
appointment of that teacher.
and subsequent appointment.
Yes, sir.
On pre-made by the petitioner. That is adjourned. This system after 1 week.
Much
Obliged. Obliged.
from supplementary list, item number 1.
May it please your lordship.
Why is the prayer made for bail filed under the...
My lord, I have filed an application under 482, my lord, CRPC, to set aside the order, my lord, dated 18/07/2023, my lord, wherein the learned trial court has rejected my default bail, my lord.
Default bail?
Yes, my lord, has rejected my default bail, so I have filed an application under 482 CRPC, my lord, to set aside the order, my lord.
The proper provision would be a revision, isn't it?
My lord.
Would it be a revision, Dr. Musika?
My lord, what happened here? They also filed a proper bail application, my lord, in the same matter. And after some argument, they've withdrawn that. Simultaneously, they filed under 482 also.
Before the trial
Before your lordship, my lord.
Before this court?
Yes, my lord. My lord, I agree with my learned senior, my lord. But, my lord, that application was filed on merits, my lord. And that was on the order dated, which was, we have challenged the bail order of the trial court, my lord. The order dated of the trial court is the 20th August 2024, my lord. No. 23, my lord. 20th August 2023, my lord. So that was on merits, and this is my statutory bail, my lord. So it has a different jurisdiction, my lord.
No, we're looking here at the relevant provision. Yes, Dr. Musika. Even without going to the formalities of the provisions, if the petitioner or the accused is entitled to go on default bail, why was it...
But the question of, my lord, what happened, my lord, under the NDPS Act, there's a provision for extension of time for investigation, my lord. The London Trial Court has extended the time by 45 days, my lord. So since the time was extended, my lord, in fact, that is reflected in the order itself, my lord, which they've challenged.
The provision is there.
My lord. So it could be extended up to 6 months, my lord.
I think the outer limit would be 180 days.
Yes, my lord. My lord, yes. My lord, let me advance my arguments, my lord.
My lord, if lordship kindly sees the last page, my lord, the order which is under challenge.
Yes.
18/7/23, my lord.
Yes.
My lord, the third paragraph. In fact, I can read the entire order, my lord. CR put up before me, seen the application filed by the accused Sanket Dev Verma under section 167(2) CRPC for grant of bail. The application is moved by Srimati S. Nausej, advocate. This application has been filed for grant of bail to the accused person on the ground that the prosecution has failed to file the charge sheet within the mandatory period of 180 days. Sri J.I. Nongrum, London Council, appearing for DI under instruction of so-and-so, submit that in view of the court having extended the period of investigation for another 45 days, the grant of bail to the accused on grounds of the IU having failed to file the charge sheet within 180 days does not arise. I agree with the submission of the London Council for the DRI. This court has extended the period of investigation for another 45 days and thereby allowed further remand of the accused beyond the period of 180 days. The grant of default bail to the accused person does not accrue. Hence, the bail application is rejected and disposed of.
My lord, kindly let me advance my arguments, my lord, on that aspect, my lord. I will satisfy your lordship, and there is a judgment also, my lord, which the Honorable Supreme Court says that, my lord. I'll supply the judgment, my lord. My lord, I will advance my arguments first, my lord. Then I will come to the judgment, my lord. My lord, the petitioner in this petition has challenged the order dated 1807-2023, my lord, passed by the learned trial court, my lord, wherein my application for default bail has been rejected, my lord. My lord, the sole legal question involved in this petition is that, my lord, whether the learned trial court can dismiss my default application of the petitioner, my lord, on the ground that since the remand of the petitioner already extended by 45 days, thereby the default application is not maintainable, my lord. My lord, before discussing this law points, my lord, may I be allowed to state few facts, my lord. My lord, kindly come to page number 4 of the petition, para number 6, my lord. My lord, may I read, my lord?
Yes, ma'am. Para 6.
Yes, my lord. Page 4, my lord, paragraph number 6, my lord.
Yes.
That in term of section 36A, subclause 4 of the NDPS Act 1985, the investigation in case of commercial quantity must be completed within 180 days by the prosecution. However, the said period can be further extended by 180 days on showing sufficient cause and report of public prosecutor. The calculation of the days is as follows, my lord. My lord, I was remanded on 14/01/2023, the date of remand, my lord. That is 18 days to 31/01/2023. Then February 2023, it's 28 days, my lord. March 2023 is 31 days, my lord. Then April 2023 is 30th day. May 2023 is also 31st day. June 2023 is 30th day. 14 June 2023 is the date of which I filed the default application, my lord. Is 14 days, and total days is 182 days, my lord. So admittedly, I filed my default application on the 14th July 2023, my lord.
After 182 days.
Yes, my lord. My lord, then the matter, when I filed the bail application, my lord, on the 14th July 2023, my lord, then the learned trial court has passed an order, my lord, which is at page, my lord, page 17, Annex just C, my lord.
Yes.
Order dated 14/07/2023, my lord. CR put up before me, seen the application filed by the accused Shri so-and-so under section 167, subclause 2 CRPC for grant of bail. This application is moved by so-and-so. This lists this matter on Tuesday, that is on 18/07/2023, my lord. So, my lord, the respondent, my lord, that is the prosecution, on 12/07, my lord, 2023, that is on 180 day from the day of remand, my lord, has filed the application, my lord, for extension of period, my lord. Admittedly, the application for extension of period also, my lord, was listed on the 18th, which on the same day of my default bail application, my lord, for hearing, on 18/07/2023, my lord. The learned trial court, my lord, had took 6 days period, my lord, that is from 12 July 2023, my lord, to 18 July 2023 to decide the extension application of the respondent and also to decide my default bail application. My lord, during this period,
When was the application filed for extension?
on the 12th, on the 12th July 2000,
So
yes,
that is on the 180th day.
yes, from the date of my remand, yes, my lord. My lord, then during this period, my right to default bail has accrued, my lord. So, my lord, I have filed the bail application on the same on 14 July 2023, my lord. Now, coming to the question of law, my lord, to this judgment which I have submitted, my lord. Now, the Honorable Supreme Court says that, my lord, in the judgment title as Jasbir Singh, my lord, that decided on 1st May 2023, my lord. The Honorable Supreme Court has clearly laid down that once the default bail has filed, my lord, the right of the accused, my lord, of the default bail, the court has no option but to grant the default bail to the accused person, my lord. It was further held by the Supreme Court that the learned trial court cannot say that it will first decide the extension application, my lord, and then it will decide. My lord, page number 77, my lord. Page number 51, my lord. My lord, the right to be released, para number 77, my lord.
77,
Yes, my lord.
please.
The right to be released on default bail continues to remain in force if the accused has applied for such bail, notwithstanding the pendency of the bail application or the subsequent filing of charge sheet or the report seeking the extension of time by the prosecution before the court, my lord. And also the paragraph above, my lord, says that if such application would have been filed before the court, have no option but to release them on statutory default bail. The court could have said that since the extension application was pending, it shall pass an appropriate order only after the extension application was decided. That again would have been something contrary to the
You're reading
well.
same paragraph.
No, my lord, the para above, my lord. Para above, my lord, line number 1, 2, 3, 4. Line number 4, my lord, after 91st day, my lord, full stop, then if such application, my lord, would have been filed, comma, the court would have no option but to release them on statutory / default bail. The court would not have said that since the extension application was pending, it shall pass an appropriate order only after the extension application was decided. That again would have been something contrary to the well settled position of law. This litigation is an
Yes, the proposition is understood. Now,
Yes, my
what
lord.
is to be examined is whether your application for grant of default bail was filed prior to the application for extension or vice versa.
Yes, my lord.
So now,
My lord.
where is the record which says that? Yes, Mr. Document, do you have the?
I'll file an affidavit, my lord, because when the application was filed, that is not
I
available.
think that is only point to be determined.
Well,
According to the judgment that you have read out,
Yes, my lord.
if the application for extension has been filed prior to your application for grant of default bill, then you have no case. If it is, like again I'm saying, if it is vice versa, then we just have to
that is one aspect. The second aspect, well, they are coming after 1 year, my lord. The impugned order of 18/7/23, my lord.
or 23.
Yes, my lord. For that, my lord. My lord, this is a 482 petition, my lord, for quashing of the order dated 18/7.
What happened in the meantime? What is the state of the status of the case?
The evidence is, it's still in the evidence stage, my lord, in the trial court. And the accused is still in
So,
custody.
my lord, default bill, whether it can be invoked after 1 year, that is another question.
No, my lord, this is a 482 petition, my lord. It's still maintainable, my lord. And there is no delay in a 482 petition, my lord.
How can you say that? You see, the issue of delay is always present in all legal applications. That has to be, because the issue of delay would point out to the conduct of the party. If you have by your own conduct caused delay or acquiescence or lashes, then the court cannot help you, or rather the system cannot help you. If the impugned order was passed on 18/7/2023, what prevented you from coming to before this court or any other forum for that matter immediately?
In fact, they filed a normal bail application
has that been explained?
after argument that was withdrawn.
This application is still maintainable, my lord. Still maintainable because I filed an application under 482, my
Show
lord.
me the law.
Yes, my lord.
It says that.
So, my lord, grant me 10 days or 15 days time. I'll file an affidavit also, my lord, taking both the pleas and bringing on record when our application was filed actually.
My lord, the aspect of when the prosecution had filed the application for extension on 12 July 2023, my lord, still I cannot file my default bail application. It would be premature, my lord. Of course, I have to file after 181st day or one. Yes, my lord. Yes, my lord.
So if suppose we are on hypothesis now.
Yes, my lord.
if you had filed the application for default bail on the 181st day and the application for extension was filed on the 182nd day, then you would have a case. But if the application for extension was filed on the 180th day and you had filed your application on the 181st day,
But my lord, that application was not decided, my lord.
it's not a question of the decision, it's a question of
But my right to be heard to be, it's also there, my lord.
Let him file an affidavit, my lord. Then at least facts will be clear. Then they can argue on law.
And also, please you better clarify with this court as to whether this is the correct provision. 482 is the correct provision, or it would be a revision or an appeal or whatever. Heard the counsel of the parties. Dr. N. Musica, the DSGI, has something that he may be allowed to file a brief response to the petition filed by the petitioner here. On prejudice, the same is allowed. This is matter up to
2 weeks.
2 weeks. How many witnesses are there?
Only one petition.
No, how many witnesses have been examined, or how many witnesses are?
6 witnesses have been examined, the remaining 4 witnesses, my lord.
Then you should have waited. It's just matter of 1 month to 1. If you are innocent, you would have been acquitted. If not, even if you are allowed to go on bail, let's say for academic purposes, even if you are allowed to go on bail,
Yes, ma'am.
if you are convicted, you still have to go back. Right.
2 weeks.
Thank you.
Highly applied, my lord.
From daily list, item number 1.
I'm to file the written argument, my lord. So I'll be filing in the course of the hearing. And my lord,
My lord, I am also. I prepared it, my lord, but because of my hospitalization and all that, my lord, will kindly grant me 3 days time, and I'll file.
These are,
Within 3 days, I'll file it, my lord.
I think, when we give our report for any committee or the Supreme Court for the matter, this is one aspect that we have to highlight. Why cases are delayed? Somebody is hospitalized.
I understand.
Somebody is having a headache.
True, my lord.
I understand.
Only 3 days, my
The court
lord.
would be sympathetic to such a request, but then on preliminary parties, I, Dr. N. Musica, senior counsel, appearing for the petitioner. You are for the petitioner.
But I am petitioner in.
For the petition.
My petitioner will do.
Petitioner in 21 or 20?
21.
21 has submitted that he may be allowed some more time to file the written argument, as the same could not be filed due to his personal inconvenience on being hospitalized in the recent past. You are in?
My lord,
21 or 28?
21.
You are in 28.
I'm in 21.
He's for the sports council.
Oh, you are for the respondent. Mr. K.P. Prasadi, GA, appearing for the respondents. State respondent in 21 no, has also expressed similar difficulty and has also submitted that the written argument on behalf of the state respondent could not be filed and has sought for time. On pre-meet, seems allowed. This is matter of 2 weeks.
Item number 2.
court. I think this matter was heard.
Yes, partly it was heard. So I'll just take my lords to the annexures once again. Then it is the state who has to satisfy this honourable court whether an unqualified person can be a member when she doesn't have that requisite degree. That is the only core question, my lord, which has to be decided by my lord.
Again, time and again, this court has requested the state or the respondent to clarify as to what would be the qualifying mark
What are the guidelines or rules to be followed
or the standard
for
as
appointment
far as
of a
qualifications go? Whether it would be solely on the basis of educational qualification
Or it is the
or experience or otherwise. But that could not be ascertained. Neither the MPSC nor the state government has been able to bring out any.
Because the Lordship, that's through the convention. Even Lordship, for example, for appointment of a presiding officer in the district council court, the convention followed is that the district council will write to the High Court for appointment of any judicial officer, or their preference would be a High Court judge. But normally what the High Court judges does is that they appoint a district judge to go for the interview, to conduct the interview. Similarly, in this instant case, and the letter has been written by the MPSC to the concerned department for a member, appointment of a member who has a special in the subject of Garo Lordship. So that is why the concerned department has
Special knowledge in the
Same thing.
in the subject.
Lordship, in this regard, Lordship, I have filed affidavit.
If I can open my case, my lord, then they can argue the matter.
even for appointment of judicial officers in the district court, Lordship. A High Court judge goes and become a panel of members of the interview
See,
board.
it's the moot
That
point
is
to
the
be,
convention
the
followed.
moot point, apart from the facts,
it has
apart
to-
from
it
the
has to
moot
come-
point to be determined is
Yes.
that is the only
Yes,
question.
yes. But now, my lord, neither there is a notification. Now, what my friend has projected, if it is taken to be the truth, my lord. Now, District Council has written to the Honorable High Court to send a judicial officer. But High Court will examine, my lord, definitely, my lord, for appointing a judge in District Council, my lord. Now, High Court will not send a magistrate first class. It has to, the High Court has to examine, my lord, who will be the best person to be a member of the select committee, my lord. Now, in case, my lord, now, if we further elaborate the issue, my lord, for example, my lord, if a person, what is the role of that person? Definitely she will ask the questions and all. And definitely a marks will be given by the selection board. Probably she is not the one who will be giving the marks, the other three, my lord. Now, whether she is competent to ask the people who are present before her, my lord, for the selection process, my lord, whether she is competent to do that, whether she was, now for example, my lord, an IAS has to be appointed. MCS cannot conduct an exam for an IAS, my lord. What is my
Here has 30 years experience in
Maybe.
subject of Garo Lordship.
Maybe, my lord. Maybe.
30 years.
Maybe, my lord. She has 30 years or 50 years of experience, my lord. It doesn't give her the authority, my lord, to be the examiner. I will open my case, my lord. Let him satisfy his honorable court.
Yes.
If my lord may kindly come to Annexure 4, my lord. Page 31, my lord. There was a notification published by the Meghalaya Public Service Commission, my lord, dated 24th March 2015. Application was
So, just asking that, right? Oh,
application offline, online in the commission prescribed for A4, AF1 are invited from the genuine citizen of India who are desire to apply as per the terms and condition of this advertisement for recruitment to the various category of posts specified in the table below, application will be received up to 5 p.m. on 24th April 2015, and no application will be entertained after the closing date. For online application through MPSC website, closing date is 23:59 hours on 24th April 2015, after which the link will be disabled. Name of the post, lecturer in Garo in Government College of Meghalaya. There was 10 posts, my lord.
Yes.
Now, my lord, after this advertisement, my lord, what was the process of selection, my lord? If my lord may kindly come to page 34. Para, if my lord may kindly see para 8 is in between the page, my lord. Para 8, method of selection.
Yes.
The final selection / recommendation of suitable candidates against the vacancies notified in this advertisement shall be made by the Commission through any of the following process. For typing speed and all that are not, we are not concerned with that, my lord. My lord may kindly come to escape to serial number 4, my lord.
Yes.
Serial number 4, written examination followed by personal interview.
Yes.
Now, my lord may kindly see, after this, my lord, what has happened, we have participated in the process of selection, my lord. An admit card was issued in page 37, my lord, dated, my lord may kindly come to page 37, dated 26 February 2016 to 26 February 2016.
Yes.
This was for the, they have informed the subjects, my lord. Time, date on 19th March 2016, time 9 a.m. to 12 p.m.
This is the admit card.
This is the admit card, my lord. And the venue of the exam was, my lord, St. Xavier's Secondary School, Tura, my lord.
Mr. D, you're not challenging the process as such.
I am challenging the composition of the yes. Yes.
Only to that. You see, only,
Yes.
only in that
But I'm just
respect,
taking, my lord. So, my lord.
But as far as the process, how it goes, whether you see the written exam was held or not, or you're not on that.
No, we are not concerned about that, my lord. But whether I have qualified for the written exam or not, that I am coming to, my lord. There was two parts, my lord. One part was the written examination. After I qualified for the written examination, I was called for the personal interview, my lord. So I'm just taking, my lord. Then 2 admit card was issued, my lord, to both the petitioner on page 37 and 38, my lord. And then, my lord, the exam was held on 19 March 2016. And if my lord may kindly come to page 39, my lord, Annexure 6.
Yes.
This is the result notified of the written examination. On the basis of the written examination to the post of lecturer in Garo in Government College of Meghalaya held on the 19th March of 2016, the candidate bearing the following roll numbers are declared to have qualified to appear for the personal interview in orders of roll numbers. Now, my lord, may I kindly see roll numbers 7 and 8, my lord. I have cleared my written examination. 7 and 8, serial number 7 and 8. Now they said in this result, my lord, the personal interview will be held on 26-27 May 2016 in the office of the Meghalaya Public Service Commission, Shillong. Intimation letters are being dispersed to the candidate concerned and the result is also displayed on the MPSC website, my lord. This notification was of 6th May 2016. Now, my lord, for the personal interview, my lord, again the admit card was issued on 9th May 2016 to both the candidates, my lord. Now, my lord, my case is this, my lord, is on page 42, my lord. So, I appeared in this exam, my lord. Then I have written on 29/6/2016 a letter, my lord, when it was brought into my notice, my lord. The type copy is on page 43, my lord. With reference to the subject cited above, we the undersigned would like to inform you that as per the notification dated 6/5/2016, the undersigned was declared qualified for appearing in the personal interview for the post of lecturer in Garo subject in the Government College, Meghalaya. The undersigned appears before the selection board members for personal interview on 26 June 2016. The board member comprising of 4 members, out of whom 3 were the members of Meghalaya Public Service Commission and 1 Sri so and so is the private respondent, my lord, was empaneled as expert member. After the interview, the undersigned on the very day came to learn that the expert, namely so and so, qualifications MA Economics, and she does not possess requisite qualification in Garo subject for her to be empaneled as an expert members in the said interview board. Since the expert was not authorized to be empaneled as an expert, therefore a fresh personal interview of the candidate by proper interview board, including adequate members from the field of Garo subject. As the interview was conducted by the expert for a different field, the entire process is vitiated. So you are kindly requested to conduct fresh personal interview and therefore thereafter to publish the fresh select list on the basis of the fresh personal interview, for which we shall ever be grateful forever. Now this serial number 7 and 8, they have filed this representation. And this representation was filed on 29/6/2016, my lord. And my lord, on 30th May 2016, the Meghalaya Public Service Commission, my lord, they have notified who has passed the written examination. My name was not figured, and even both the petitioner's name was not figured, my lord, here. That is on page 44, my lord.
Yes.
On 30th May, my lord, the result of the interview board for the post was notified, my lord. And the select candidate recommended by the commission are as follows, my lord. The recommendation of the candidate shall confer no claim for the appointment unless the appointing authority is satisfied. After such inquiry as may be considered necessary that the candidates are suitable in all respect, my lord. Now select name was forwarded to the government, my lord. And in between, my lord, I filed my representation in between. But they have neither disposed my representation, nor, my lord, they have acted upon that, my lord. And then the result was, the appointment letter was issued on 27 February 2017, my lord. After almost 6 or 7 months, my lord, the result was declared. My case is this, my lord, only as I have read the complaint which was filed by us, my lord, is this: when you are not an expert, you are from MA, my lord, MA, master degree, my lord, can you be empaneled as an expert for a Garo subject, my lord? Now, my lord, my learned friends, they are not in a position to show before this honorable court, my lord, that there is a notification to that effect, when, if in case a qualified person is not there, then, my lord, a person who acquired knowledge about Garo, my lord, can be empaneled, my lord. They was not able to show that notification, my lord. Now, my lord, one of my friend has also said, my lord, that it is a convention. Can a convention override the system, my lord? It cannot, my lord. If, my lord, the requirement is for a Garo, my lord, for appointing a Garo lecturer, my lord, a qualified person has to be there. Probably she has acquired knowledge. For example, my lord, I am from the state of Meghalaya. I am from Khasi, my lord. I know Khasi, my lord. I understand, I read Khasi, my lord. It doesn't mean that, my lord, for selecting a lecturer of Garo, my lord, or Khasi, my lord, I can be empaneled, my lord. So, my lord, only by acquiring a knowledge, my lord, or by experience, by teaching, my lord, can I substitute in a selection committee, my lord, with an expert who was required to be there, my lord. If in case, my lord, Meghalaya doesn't had an expert in Garo subject, my lord, they could have hired from Assam, my lord. Assam also there is a Garo lecturers, my lord, where they have the degree holder, my lord. Entire Gwalpara belt, my lord, Garo lecturers are there, my lord. They could have asked someone to come from there, my lord. That is my case, my lord. Subject to my learned friends, my lord, what they will, I will reply, my lord.
Wait, please, Lordship. Lordship, in this matter, Lordship, the only issue is the empanelment of the respondent number 6 as a subject expert in the interview board of the MPSC, Lordship. For Lordship, for deputing a subject expert in the interview board of the MPSC, there is no laid down norms or guidelines, Lordship. It's by way of a conventional practice, Lordship. In this, Lordship, I have filed this affidavit, which I have filed, Lordship, on November 2023. One affidavit I have filed, Lordship. November 2023. Filed on 1st December, sorry, Lord, 1st December 2023. 1st of December 2023.
Yeah.
Yes.
1st December 2023, Lord. This is the affidavit filed by the Secretary to Government of Meghalaya Education Department at paragraph 2, Lordship. Paragraph 2.
Yes.
If I may read it, Lordship, paragraph 2. That by order dated 17/11/2023, this Honorable Court had directed the State Respondent to seek instruction relating to the particulars of the criteria laid down for a person to be qualified as an expert to be empaneled in the interview board of the MPSC for selection process conducted by MPSC. In pursuance of the said order, the Respondent Department has furnished instruction along with the deputation order dated 24 May 2016. In connection with this instant case, whereby the respondent number 6 was deputed as expert advisor to assist the MPSC in the interview for recruitment to the post of lecturer in Garo in government colleges. Paragraph number 3. The deponent submit that the deputing of subject of expert member in the interview board of MPSC is by way of conventional practice. Whenever the MPSC requests for expert advisor, the department concerned will depute a senior lecturer or head of department of the concerned subject to assess the commission in the interview board for selection process conducted by the MPSC. In this instant case, the respondent number 6 was deputed as expert advisor in the interview board of the MPSC for selection to the post of lecturer in Garo in government college. Page 7, Lordship. Page 7. Page 7, this is the order. Page 7 of the affidavit.
Yes.
With reference to your letter on the subject, I am to inform you that the recruitment is conducted by MPSC, and whenever MPSC requests for expert advisor, it is a conventional practice that the head of department or senior lecturer of the concerned subject from government-aided colleges are deputed as expert advisor to assist the commission in the interview board of MPSC for the post of lecturer in government colleges. In this regard, it may be informed that for this particular recruitment for the post of lecturer in Garo in government colleges, which was held on 26-27 May 2016, Shrimati So-and-so, head of department of Garo Ledikin College, Shillong, was deputed as expert advisor to assess the commission in the interview board of the MPSC. And page 8 is the letter requesting for deputing a senior lecturer to assess the interview board. And page 9 is the deputation order. Page 9 is deputation order. With reference to the subject cited above, I am to inform you that Shrimati So-and-so, head of department of Garo Ledikin College, Shillong, is deputed as expert advisor to assess the commission at the interview for recruitment to the post of lecturer in Garo in government college to be held on 26-27 May 2016 from 11 onwards. Now, Lordship, I'll take your Lordship to my affidavit in opposition. Affidavit in opposition filed on 30th October 2018. My main affidavit, Lordship, filed on 30th October 2018. This is the affidavit filed by the Joint Secretary.
Yes.
Lordship, at page at Annex 1, page 5. Annex 1, page 5 is the appointment letter of the respondent number 6. Annex 5, page 5, Annex 1. Type copy is at Annex 6, is at page 6A, Lord. Type copy. And type copy is Annex 6A, page 6A. 6A, Lord.
Yes.
Subject, Lordship, subject, appointment of Mrs. Bharati B. Sangma, MA, as full-time lecturer in Garo and Lidikin Girls College, Shillong, on ad hoc basis. In inviting your kind intention to the subject cited above, I would like to state that one post of Garo lecturer could not be filled up till now due to non-availability of suitable candidate. Mrs. B.B. Sangma submitted her particulars after the date of the interview was over. However, the governing body of the college, finding her application suitable for accommodation, has recommended Mrs. B.B. Sangma for appointment as full-time lecturer in Garo on ad hoc basis. Copy of GB resolution is enclosed herewith. Particulars of Mrs. B.B. Sangma, I shall be grateful if you will kindly give your approval to the recommendation to enable the college to appoint her before the college reopens after the winter vacation. Appointment at page 8.
Page 7.
Page 8. Page 8 is the type copy.
You're not given
approval of the appointment, page 8.
Yes.
This respondent number 6 is at serial number 3. Serial number 3. The appointment of the following person as lecturer in Lidikin Girls College, Shillong, against the post mentioned against each with effect from the date of joining as per the Assam Aided College Employee Rules as adopted by the Government of Meghalaya and as recommended by the governing body of the college is hereby approved. As serial number 3 is the respondent number 6. The appointment is of the above person from serial number 1 who is subject to the condition that they should obtain MPhil or PhD degree within a period of 8 years, failing which their annual increment would have to be stopped. In joining letter at page 10, joining letter of the respondent number 6, page 11 is the type copy. She joined in the year 1983. Joining letter dated 31st March 1983. And the confirmation of her service is at page 14, Annex 5. Confirmation of the service of respondent number 6 at page 14, Annex 5, Lord. Page 14, Annex 5.
Yes.
At serial number 2. Under the authority of the government order, the services of the following
14.
lecturers. Page 14, Annex 5. At date is 24/3/1988. Confirmation order.
Yes.
The respondent number 6 is at page serial number 2. Serial number 2. Her service has been confirmed in 1988.
Yes.
At page 15 is the page 15. Page 15 is the relaxation with regard to the qualification for appointment of lecturer in the language Khasi, Garo and Mizo. Here the relaxation is that they
Net may not be required.
yes, net is not required. Only master degree or with MPhil or PhD.
Yes. Yes.
So, Lordship, this is my humble submission is that the respondent number 6, Lordship, is qualified for to be impaneled as a member in the as an expert member in the interview board of the MPSC, and since she has got the qualification, Lordship. That is my humble submission.
If I can just reply to my friend, then it will be easier, my lord. Otherwise, it will all jumble up, my lord, for me to reply. I'll just reply, my lord. I will take to these notifications only and letters which my learned friend has apprised this honorable court. I'll just take, so one by one I can give the reply, my lord. Otherwise, it will jumble up, my lord. Where to reply, I will be very confused.
What would be the stand of the other respondents? It mean
Few of the private respondents.
yes, but as far as you are concerned, you would have no role in the selection process.
Absolutely, Your Lordship, but I would like to make some submission regarding the issue that has erupted since 2016. Now we are sitting in 2024, Lordship. Now there is a recent judgment passed by this honorable court also, Your Lordship, that if a person has been seated in a particular place for a longer period, to unseat that particular person is against public.
The application of the principle of equity will always be there.
That is, in my case only, my lord has passed, my lord.
When you see that the writ petition was filed in 2017,
Since it is in his case, then he will support you.
when you see the manner in which the petitioners have conducted the case.
That is always
There was, my lord.
that is always there. That is always there.
So, Your Lordship, I will placing few of the judgments before Your Lordship. I place those
My lord, there was 15.
My second submission is that they have participated in the entire process and they have declared unsuccessful. My learned friend has read the representation, then the results, but the fact is that after the results was declared, then only the representations was filed. Not that representation was filed before, after the interview. The date is very clear, Your Lordship. The results was declared in May. They filed the representation in June. So I'll place those decisions regarding Your Lordship.
So, Mr. Day, I think we'll allow them to.
Yes, yes, definitely, my lord. They have to, my lord.
Then you can,
My
then you
lord,
can
my lord.
apply,
My lord, my lord.
Respondent. You're for respondent?
Respondent number 4 and 11, or 7 and 11. Your Lordship, my submission will be that the convention is that Your Lordship has seen, my learned friend has read. It's not through experience also, but she was teaching in the subject of Garo, Your Lordship, since 1983. She was regularized in 1988. Since 1983 till the date of retirement, she has been teaching in the subject of Garo lecture. And there's a notification of relaxation that only master degree is required. And she is a master degree in economics. That's besides the point. The point is that 30 years of teaching in Garo subject, she already has that, possessed that. And that has been affirmed also by the principal of Lady King College, which has been filed by the respondent number 6. My second argument is that, Your Lordship, once a person has already participated in the process, they cannot take a U-turn and come and challenge the same after being declared unsuccessful. My third argument, Your Lordship, is that now the writ petition of 2017, we have been appointed now for over 8 years. We've been working on this as Garo lecturers. Now to unseat us at this stage, Your Lordship, will be against the public interest. That is my 3 grounds of submissions. And I'll place those judgments, Your Lordship. If Your Lordship requires a written argument, I will place all those judgments on the law that once you have participated, you cannot turn around. And on secondly, on the ground that the question of unseating a person at this stage, when he's been working for a very long period, Your Lordship, the question does not arise.
Yes, you can do that.
Obliged.
Your Lordship, I'm appearing for respondent number 3, 4, and 5. Here what happened, Your Lordship, the MPSC normally by convention used to write to the department concerned. Here only the department concerned knows very well who is the senior most and who is the qualified person, Your Lordship. But it's only in 2023, and when the 4 years course education program has come up, then a notification has come, Your Lordship. That is 2023. That the expert should be from NIHU, Your Lordship. I can show Your Lordship.
That would be
will not
material.
apply to that case.
That
That's
would
only
not be-
23. Before
would
that,
not be
Your
applicable.
yes, Your Lordship. Before that, Your Lordship is convention, just write to the department concerned. And
Do you have any?
no, Your Lordship, because
notification?
that's the what you followed. That's conflict long time back, Your Lordship. You just write to the department. The department.
Where is your requisition here?
Your Lordship. Your Lordship, in the affidavit filed by the state, Your Lordship,
You have not filed any affidavit.
we have submitted that we'll rely on the affidavit filed by the state because, Your Lordship, all the records is with the state. Affidavit in compliance of order dated 17/11/2023, Your Lordship, filed by the state respondent.
Yes.
It's also page 8, Lordship. Your Lordship has got it, Your Lordship.
Yes.
From OS Marak, Under Secretary, Government Media Education Department, to the Director, Technical Education. I'm directed to enclose here with a copy of the letter and so and so received from the Under Secretary MPSC Service. I request you to repeat suitable officer with contact numbers as per which will be held on so and so in the office of MPSC also. I think the only issue here is that because in the private respondent has been teaching since 1984. In 1984, Your Lordship, there's no MA economics in Your Lordship. So but the state government has relaxed only for having degree in Garo and who is a master who is MA. That's the only they are raising the ground because after that, Your Lordship, because that in 1984 there's no Garo language or in MA Garo. That's why. That's the only issue which they have. But she has been all.
Is she a BA Garo?
Yes, Lordship. She's in.
But she's economics.
MA economics. But in degree level, Garo also she has.
In degree level, she's Garo. Where is her? Again, can you just well.
The affidavit filed by the state, Your Lordship. Your Lordship, in that issue that we clear from the affidavit filed by respondent number 6, Your Lordship. Affidavit filed by respondent 6 in detail her qualification, Your Lordship.
Whether the degree level, if she has, if Garo is one of her subject, then.
Your Lordship, we have got the affidavit in opposition filed by behalf of respondent number 6.
Yes, sir.
Your Lordship has got it, Your Lordship. It's 11 pages, page 4, Your Lordship, paragraph 10. Page 4, Your Lordship, paragraph 10.
Yes.
May I read, Your Lordship? That with regard to the amendment stated in paragraph 10 of the petition, the answering independent states that the then principal of Litigant Girls College, by the letter number dated 6/184, sought approval of the governing body recommendation of the deponent as full-time lecturer in Garo from the Director of Public Instruction, Meghalaya, Shillong. Accordingly, by order memo dated 24/3/1984, the deponent was appointed as lecturer in Garo against the post created in government letter number dated 19/3/82 in Litigant College. The then principal Litigant College with number dated 26/3/84 informed the deponent of her appointment, to which the deponent submitted her joining report dated 2/4/1984. Thereafter, by order memo the deponent was confirmed under the Assam Aided College rules as adopted by the government of Meghalaya as lecturer in Garo in Litigant Girls College. Presently, the deponent is holding the post of assistant professor and vice principal of Litigant College till date. The deponent for this stated prior to 1984 there was no Garo subject in postgraduate level, and all lectures in Garo held MA, other subjects in Garo, as a subject at degree level. Your Lordship, Your Lordship has got it. And Garo as a subject at degree level. It was only in the year 1996 that the Garo department was introduced in Nehu, Your Lordship, in Tura campus.
Yes.
That's my submission.
Any other respondents?
Yes, I will just
Quite a
reply.
number of respondents. Who's appealed?
Right, respondent.
Probably it will be the same reply.
Respondent?
What Mr. Pillang is-
Respondent number 6.
Respondent 6. What have you to say for yourself? Everyone has spoken in your favor or against you.
Sir, I'm relying on my own affidavit in opposition, sir. Respondent number 6. I'm relying on paragraph 10, sir. Page 4, paragraph number 10.
Paragraph 4.
Page 4, paragraph number 10.
I think that a while ago Mr. Kriam had read this. So you are reiterating the same. So you're relying on this.
Yes, sir.
Apart from this, anything else?
Yes, sir.
Apart from this, anything else in your?
Sir, I want to place a paragraph number 12 also, sir. Page
12.
5.
Yes. Paragraph 12, yes.
May I read, sir?
Please.
That with regard to amendments made in paragraph 12, 13, 14, 15, 16, and 17 of the petition, the answering opponent reiterates paragraph 11 of this instant affidavit and further states that by letter number so-and-so dated 24th May 2016, she was deputed as expert advisor to assist the commission at interview for recruitment to the post of lecturer in Garo in government colleges. The opponent states that the question asked during the personal interview were purely based on the basis of teaching demonstration undertaken by the candidates as the subject expert and topics relating to the syllabus and subject consent. So, please come to Annexure 7, page 19, sir. Recruitment to the post of lecturer in Garo in government colleges. With reference to the subject cited above, I am to inform you that Shrimati head of department in Garo Litigant College, Shillong, is deputed as expert advisor to assist the commission at interview for recruitment to the post of lecturer in Garo government colleges to be held on 26 and 27 May 2016 from 11 a.m. onwards. The person concerned is being informed her contact number ...
Yes.
A letter dated 24th May 2016.
Yes. Who else?
I'm for respondent number 8, 9, 10,
Who's
12 to 15.
Who's respondent in 10?
They are the appointed lecturer, Your Lordship. They are the appointed lecturer.
So all these respondents 7 to 15.
Yes, Your Lordship.
They are all
They are all appointed.
appointed.
Yes, Your Lordship.
So I'm representing only 8, 9, 10 and 12 to 15, Your Lordship.
You were also appointed at the same
Yes, Your Lordship.
at the same time
Yes, Your Lordship.
when the other
Yes, Your
respondents
Lordship. Same time. Adopting to the argument advanced by my learned friends
That is what I was
for the respondent, Your Lordship.
What's particular or specific argument you would
Nothing much, Your Lordship. Apart from that, if Your Lordship would just go through the entire writ petition and rejoinder affidavit being filed by the petitioner, Your Lordship, there is nothing, no averment made against the appointment that they are aggrieved by the any of whether we possess necessary qualification or not, or anything as such. Throughout their petition and throughout their rejoinder affidavit, they have never made any kind of averment stating that the appointed candidates do not possess any kind of necessary qualification or requisites qualification, Your Lordship. Throughout their only grievance is that with regard to the expert committee.
There is no prayer made against.
Yes, Your Lordship. Yes, Your Lordship. Nothing.
As far as qualification is concerned.
So adopting to all the argument placed by my learned friends, Your Lordship, my humble submission is that only, Your Lordship. Since all the appointed candidates have been serving for quite a long time, so ousting them at this point of juncture will not.
Yes.
Now, my lord, I will reply jointly of all the submission they have made, my lord. First, my lord, what Mr. Pilang, my friend, has submitted, that, my lord, the matter was filed in 2017 and today we are standing in 2024.
Yes.
Now, my lord, the last affidavit of the government has come in the year, my lord, 2023, my lord. The second affidavit, government has filed 2 affidavit, my lord. The first affidavit was filed in the month of, my lord, by them. The first affidavit was filed on 26 October 2028, my lord. Was sworn when they have filed, it is not mentioned, my lord. But the last affidavit, 2018. The first affidavit, my lord. The first affidavit was filed in.
I was wondering how we have fast forwarded.
No, my lord. 2018, my lord.
First affidavit.
For the first affidavit. And the second affidavit which has come, my lord, it is on 26/6. No, my lord. Yes. It has come on November 2023. Where
this is
the last affidavit, my lord. So, my lord, may kindly see the delay which is accrued, my lord, is because of the conduct of the petitioner or the respondent hands are also there, my lord. Second thing, my lord, my learned friend probably has forgotten the period of COVID, my lord. The COVID has also hit, my lord, where the code was not even, my lord, we was not in sessions and all, my lord, at that point of time. Now, my lord, may kindly see the affidavit, the first affidavit which was filed by my learned friend, Mr. Kharmi. He has pointed out, my lord, that the appointment was approved, my lord. Now, if my lord may kindly see the affidavit, the annexures, if my lord may kindly come to annexure 1 of that affidavit, my lord, filed in the year 2018 that I was referring to.
Yes. Page?
Page 5, my lord, annexure 1, my lord. The typed copy, not there, my lord. Six? No, we don't have 6A. Yes. So, my lord, may kindly see.
Yes.
No, date is not mentioned in the typed copy. My lord, may kindly see 6/1/1984, my lord. This letter was issued by the principal of Ledicin College, my lord, Girls College, to the director of public institution, Meghalaya, Shillong. And what was the content of the letter? Appointment of so and so is the expert, my lord. If my lord may kindly come to page 5 itself, my lord.
Yes.
What I'm insisting in this, my lord, is this. This letter was written on 6/1/1984, my lord.
Yes.
By the principal to the director of public institution, Meghalaya, Shillong, appointment of Shri Bharati B. Sangma, MA, as a full-time lecturer in Garo in the Ledikhin Girls College, Shillong, on ad hoc basis, my lord. She was appointed for teaching Garo, my lord. And it has been approved, my lord. They have said it has been approved in the year 1984, my lord. Now, my lord, may kindly see the approval order that is on page 9, my lord. This has been written by the principal, page 9, annexure 3, 1984, my lord.
Yes.
Now, my lord, may kindly come to page 10.
Yes.
Now, this letter, my lord, to the principal, the expert is writing, giving reference to 31st March 1983, my lord.
Yeah.
This letter was written in 1983
Yes.
to the principal by an expert, and what she was informing with reference to your letter dated so and so. Now, 26/3/1984, my lord. I am giving a reference of present, my lord, and writing a letter in what has already gone, my lord. How it can be accepted, this letter also, my lord? I am giving a letter, I am issuing a letter in 1983, my lord, and I am informing that in 26/3/1984, I have joined, my lord. What is the reason? They have also not clarified, my lord. I am also not sure what.
You read the body of the letter.
Yes, my lord. I will read, my lord. With reference to your letter dated so and so, dated 26/3/1984, appointing me as a lecturer in Garo subject, in Garo, I beg to inform you that I have been joining
in Garo subject in your college.
Yes, my lord. In your college, I beg to inform you that I have joined the above mentioned post with respect from today.
With effect from today.
With effect is handwritten, my lord.
Look at the date.
22nd April 1984. 84, my lord.
4 noon.
Sorry, my lord.
4 noon.
Yes. What is my contention is this, my lord. I am addressing a letter to this honorable court, my lord, in 1983. And I am informing that I am going to join in 1984. How it is possible, my lord? Now, second thing, my lord, is this, that they have read the affidavit which was filed by an expert. My lord, may kindly see in para 10 what they have stated, my lord.
Para 10?
Para 10 of the affidavit filed by an expert. Respondent number 6, my lord.
Yes.
Now, my lord, may I take into reference the appointment. The appointment was,
yes,
the advertisement was floated in 2016, my lord.
Yes.
And what they are mentioning, that the deponent father state that prior and during 1980s, there was no Garo subject in postgraduate level, and all lecturer in Garo held MA in other subject and Garo as a subject as a degree level. It was only in the year 1996 that the Garo department was introduced in Nehu in Tura campus, my lord. Very cleverly they have articulated the affidavit in Tura campus. What about the Shillong, my lord? I'm not going into that, my lord. But from 1996, the department was there. Till 2016, there was no qualified person, my lord, they mean to say. Why specifically this expert was appointed, my lord? Now, she has also said, my lord, what my learned friend has read, para 12, my lord. If my lord may kindly come to para 12. I'll just read, my lord, the last 5 lines, my lord. The deponent state that the question asked during the personal interview were purely based on the basis of the technical demonstration undertaken by the candidate as a subject expert and topics related to the syllabus and subject concerned, my lord. This is my case only, my lord. that if you are not qualified, even if you ask the question which is written in the syllabus, my lord, whether you are correct or not, my lord, how the other people who are in the selection board, my lord, they will understand, my lord. They are not Garo, my lord. She was the only Garo, my lord. So my case is this, my lord. Even if taking their view, which was projected by the respondents, my lord, whether this can be allowed to be continued, my lord. This cannot be allowed to be continued, my lord. Otherwise, there will be biasness, my lord. So, my lord, my prayer before this honorable court will be this, my lord, that we are not asking, my lord, this honorable court to disturb the written examination result, my lord. We are saying, my lord, that the personal interview, my lord, should be held again, my lord. That's all. And I will give a written argument also, my lord, on this.
I'll also file my written argument.
Parties are allowed to file the written argument.
Within 1 week, we'll file it.
1 week.
Lordship, I have filed my main affidavit in 2018, and the second affidavit I filed in December 2023. This second affidavit, Lordship, I filed in terms of compliance of the order passed by this honorable court, which I have enclosed, Lordship. So there is needed no delay. This second affidavit is only with regard to the criteria for
the matter was
paneling subject expert.
Yes. So, heard then counsel for the parties. The hearing is concluded. However, the parties would submit that they may be allowed to file written argument, their respective written argument with related authorities relied upon. Allowed. This is matter after 1 week.
Hello.
Item number 3.
Lordship, in this matter, I'm praying for some time. Mr. Paul is unavailable today, Lordship.
Did you mention hour? You should have mentioned.
Lordship, I could not reach on time.
If it is not for the fact that they are whiling their time here, they would have agitated against your request. Any objection? Pre-made by the petitioner. This is matter after 3 weeks.
Lordship, 3 and 4 are connected.
Yes.
Same order.
3 and 4 connected.
Item number 5.
Lordship, I have similar prayer for item 5 and 6.
5 and 6?
5 and 6.
Related matters.
Lordship.
On pre-made by the petitioner, this is matter after 3 weeks. Arun.
daily list, item number 1.
Lordship, matter is coming for service report. We have filed the affidavit of service. There are altogether, Your Lordship, 14 respondents. The position is this, as per our affidavit. Respondent number 1, 4, 7, 8, 10, 11, this one, 13 and 2, they are served. And respondent number 3, he left the service and he is no longer there, and we were permitted to make a dusty service, and when we made the we have discovered that this respondent number 2 has left the service on 5/11/2019. And so far respondent number 6 is concerned, he already expired before the judgment was delivered, and this fact the counsel for the writ petitioner who was appearing was never brought to the notice of the court. And there are other respondents 5, 9, 12, 14 who have refused to accept the notice because they are not longer interested in the matter. So this being the position, Your Lordship, and none of the renting appearance.
Respondent number 1.
Only.
So what do you mean to, what do you want to say, Mr. Jindal?
Your Lordship, what I want to say that this notice are now deemed to be served. Because one of the respondent number 3, he left the service.
How can you say that it's deemed to be served? If he has left the service, what you have to do is you have to file an application to strike him off from the array of respondents.
Your Lordship, I make a oral submission that it's his name may be struck down. And the one who died on respondent number 6.
Even this also has to be brought on record as far as his death is concerned.
Yes. That we have filed the affidavit. In the affidavit, we have stated that he has expired.
Have you filed the
affidavit? I have filed.
Have you filed the death certificate?
Death certificate, Your Lordship, we are not having.
From where did
for
you
the
get,
region, Your Lordship.
From where did you get the information that he is dead?
What is my submission, Your Lordship? That these peoples, they were part-time employees.
We are not on that. We are on the issue of whether service has
service of the notice.
Notice has been affected
Lordship,
or not.
Lordship.
So, if it has not been affected, you have to take alternative steps or whatever.
Yes.
If that is the information that you have received, then you have to, you have to base your information on some documents or concrete evidence. For example, as I was saying, if for 6 you say he is dead, there must be some death certificate.
And I do not know for which are the respondent Mr. Jahai is appearing. Because he was the counsel for the writ petitioner before the learned single judge. He will be in a better position to tell what is the position and for which are the respondent he is appearing.
He is appearing for one, he said.
One. Only one. Respondent number 1. For others you are not appearing.
As of now, no wakalatnama has been given to Madam.
Because they have refused to accept the notices.
So those who have refused to accept notice, that will be on record.
Yes, that is on record. And the
only
only one has died.
We are only trying to ascertain, you see, those respondents who ought to have been issued notice and whether it has been affected or not. Otherwise, at some point of time, they will come and say, we have not received notice. Then what happens?
We have.
Where is your affidavit of service?
For that reason, Your Lordship, we have filed the affidavit, and Your Lordship may see our affidavit. Page 19, Your Lordship will see page 19.
Just move.
Page 19, serial number 4. That is, he is respondent number 6, Gurmeet Singh. And he expired on 26/8/2022. It has been reported by the officer in charge of the section that he expired.
This one.
And my friend Mr. Jaha also will confirm it, because he was appearing for him even after his death. And so far your lordship will see those people, those who have refused to accept, they are 5, respondent number 5, 9, 12, 14. I'll take to your lordship those pages. Page number 17. Page 17. The officer in charge of his section, under his signature, states that he has refused to receive.
He's your employee, isn't it?
He is my officer.
Your officer. Now that is what the problem
Yes.
is.
Because we are allowed to do the dusty service.
So as far as yes, sir. See, Mr. General, as far as the the respondents for which you said service has been affected,
Yes, Lordship.
you have also
Enclosed
you have enclosed this
track record.
record
Yes.
of the post office.
Post office.
But I believe you should also get a certificate from the post office that such and such notice has been.
Your Lordship, they do not give, they only state that track record is the proof, and which is supported by the affidavit. Otherwise, Your Lordship, what we can do, that we'll make a publication in the newspaper having circulation for all the respondents once again.
That would be a substituted service then.
And it will be substituted. Apart from the service which has been effected, we will also...
Even that, Mr. General, tell me, how many people read newspaper nowadays?
No, Your Lordship, then I have no alternative, because the consul who is appearing, who appeared...
Who was appearing earlier?
Mr. Jaha was appearing.
You are appearing for all?
He appeared for all.
Why don't you try and contact him?
My lord, I got only one. I will get it contacted.
Because we have to.
In the meantime, my lord, postal receipt, whatever.
Because, you see, as far as I mean, we should go by the conventional, procedure.
My lord.
That as far as effective service is concerned, the AD card should come.
AD card doesn't come.
See, once the AD card comes, then we are sure that.
Yes.
And even then, you know the rules of, I don't have to tell you, you have to tell me, the rules of service of summons.
Yes, Lord.
It has to be by the person concerned. It cannot be by a servant. It cannot be by a friend. So we don't know, you see, because the post office, the postman will go and postman will go and deliver. He just throw it in the post box or throw it in the through the door, and that is deemed served.
Yes.
So we don't know whether it's actually received or not. This is the situation I have encountered in most cases, where after some time parties will come and say, no, we have not received. This is not, where is our signature, so on and so forth. To be on the safe side, you have to ensure that actual service has been affected. Excuse me.
You verify, Mr. Jindal, you find the postal department, they issue certificate on the basis of the tracking details. Tracking details is no proof of service. And this is a practice which is going as on today also.
No, Lordship, that is also true, and for that reason we have filed the affidavit sporting which is also supported by the extract which we have taken out from the official website, and in the digital system which has been prevailing now, that clearly shows that so and so registered number letter is duly served on such and such time and such date.
To make it a complete proof, there is a system of issuance of certificate.
For complete proof, your Lordship.
Certificate becomes a conclusive proof of service.
No,
detail is not a conclusive proof of service. These are details obtained by you.
Apart from that, your Lordship, the counsel who appeared before the learned single judge.
That we can understand, it's a service related thing, it's up to you which you do.
That is, we have requested, it says Mr. Jha, we have requested him, he will do his.
Your Lordship,
but that is not the law. See, we cannot compel him. But we have requested him, he will do the needful. But the only thing is that we have to be very sure.
And there is one more. There is one more reason, your Lordship, that these people, they were not the regular employees, they were the sweeper part-time. They come in the morning and do the work and go away.
The facts of the case.
Go away. And
but then the next day again they come, isn't it? Next day again they come, isn't it?
Till they end service.
If they come for 4 days, they get the salary for 4 on the minimum wages. They are not the regular employees of the corporation. And they are working in the different section. That's why this court has passed the order that thus the service be affected, because they were supposed to be working part-time in our office.
Yes,
we have...
Thus the service has been affected on which respondent number?
Only affected on respondent number 2.
Only on 2?
And respondent number 3 left the service on 5/11/2019. Respondent number 6 expired on 26/8/22. That is much before the impugned judgment was rendered by the learned single judge. And respondent number 5, 9, 12 and 14, they have refused to accept.
Let us be clear. As far as respondent 1, Mr. Jha, your opinion. 2. 2 is that tracking record. Post office. So, Mrs. Nindal, what you can
Lordship.
do, as far as those respondents who who figure in this track record,
Yes, Lordship.
consignment
Lordship.
record, you better file an application or contact the post office. Let them give a certificate of.
As your Lordship passes the order, on the basis of the
we will do
order,
that.
your Lordship
We will
will
do that.
approach to the GPO.
So these are, just give me the number again.
Respondent number 1, 4.
Okay, one is done.
One is appearing.
So there'll be.
Then other respondents are 4, 7, 8, 10,
10,
11,
11,
13,
13.
and 13. These are from the postal receipt.
Yes, yes. So on 13.
Postal track record.
So we are left with.
Then respondent number 2 was served by Dusty.
That is served.
Served by Dusty.
So 2 is served by Dusty.
Then respondent number 3, he left the service.
He or she?
He or she, does he? He? She.
We are living in a neutral world. So you see, he, she.
These both look same. Sometimes difficult to distinguish.
She left. Number 3. So then.
Then respondent number 6.
6.
She or he? She expired. And he expired on 26/8/2022.
Expired. Then 7.
Then
7, 8, 9.
5, 9, 12.
5, 5.
5, 9, 12 and 14. They have refused to accept.
Refuse.
When we were permitted by Dusty service, we have tried to effect a Dusty service, but they have not accepted the notice. The one who is expired, your Lordship, my submission will be that his name may be deleted.
Excuse me. This is also this one. 3 years. So he has to confirm only as far as this. This is the post office. So that's why they didn't get the settlement. Mr. V.K. Jindal and Senior Counsel, appearing for the appellant, has submitted that notice upon the respondents have been served and an affidavit of service has been filed indicating the manner and mode in which the said notices have been served upon the said respondents. The respondent number 1 have been served and is now represented by Mr. Archa, who is present in court. As far as respondent number 2 is concerned, the learned Senior Counsel would submit that the notice upon this respondent is also deemed to have been served in as much as the same was issued through Dusty service, which which he has accordingly acknowledged. Or she. Two is she, huh?
The report is at page 13. 1-3.
The corresponding report is at page 13 of the affidavit. As far as respondent 3 is concerned, it is submitted that the said respondent has since left service, and as such it is prayed that her name may be deleted from these proceedings.
Left the service, Lordship, on 5/11/2019, around 4 or 5 years before.
It doesn't matter. Has since left service.
Lordship.
Then we come to respondent 4. So we'll allow this as far as 3 is pre-allowed. The respondent 3 is accordingly struck off from the that have come later. It becomes very confusing. As far as respondent 4, 7, 8, 10, 11 and 13 respectively, the learned counsel has submitted that notices have been also affected upon this respondent, and in proof thereof, the copy of the track what do you call this? Track consignment issued by the post office have been enclosed, have been annexed to this affidavit as Annexure 1 in series. However, this court would direct the appellant to ensure that such notices have been actually delivered and received by the said respondent, for which a certificate of service from the concerned post office may be filed before this court on the next date fix. Next, coming to respondent number 6, the learned counsel has also submitted that at para 6 of the affidavit, statement has been made that the respondent number 6 has since expired on 26/8/2022, and his name too may be deleted from these proceedings. Pray aloud. The learned senior counsel has further submitted that the notice issued upon the respondent number 5, 9, 12 and 14 respectively have been refused to be accepted by the said respondent. Mr. Jindal, see, even by Dusty also, if you present the notice,
Lordship.
they would refuse.
Refuse it, they don't sign.
They don't sign.
Don't sign.
That we,
They say we are not taking.
How do we? You have filed the affidavit, so we'll take your word for it.
Lordship, I stand by for it, Lordship.
And accordingly, the said notice may be deemed to have been served upon such respondents. In view of the above, at this stage, the appellant is directed to take steps accordingly as directed. This is matter of the
Lordship, one more submission, Mr. Jaha, who appeared before the learned single judge.
No,
he will.
The appellant, the appellant is also directed to take steps for correction of the cause title of this appeal.
Obliged.
No, this is the matter after 2 weeks.
Item number 2.
Lordship, I'm praying for some time in this matter, Lordship, due to unavailability of Mr. Paul.
This is a contempt matter, my lord, and the orders of the arbitral tribunal, my lord, of 8th November 23 and 10th November 23 have not been given effect for more than 7 months.
You mean to say that the absence of Mr. Paul is also contempt?
No, it can't be, my lord. Mr. Paul, only my prayer is, my lord, that I have one thoughts. I am only your lordship's hand, in the sense that, my lord, they are having possession of my property. They are not paying rent. Tribunal has directed them to pay the rent. And this is the short issue, my lord. Whenever your lordship, whenever Mr. Paul is available, I am there. I can say that.
We should do it.
Lordship, after 1 week.
We'll take up this. We'll take up the matter on 27th.
27th.
And if you fail to appear on that day, we may grant you adjournment, but cost of 1 crore.
Cost will be still cheap, my lord, because they have to pay lakhs of rupees. And they will,
that remains to be seen. Accommodation has been sought for on behalf of the respondent on the ground that the landed senior counsel, Mr. K. Paul, being indisposed. Mr. A. Kumar, Leonard J. Leonard AG, appearing for the state petitioner, has not objected to the prayer made, but has, however, submitted that the matter has taken quite some time, and considering the issue involved, it is prayed that this petition be disposed of expeditiously. Accordingly, the matter is adjourned for the day, but the counsels are requested to ensure that the matter be heard on the next date fix. As prayed for, this is matter on 27.
Highly obliged.
Item number 3.
May it please your lordship. Your lordship, I'm praying for some accommodation. The conducting counsel, Ms. N.G. Shilla, is not available today, your lordship. We've received the paper book.
Paper book is ready.
You have received it just now or a long time ago?
Today, your lordship.
What is this matter about, Mr. N.G.?
Yeah.
Issue involved?
Appeal, my lord.
Appeal against what?
Against judgment from the
Conviction under which provision?
302.
302, my lord.
302.
Date of incident is 1/6. Date judgment 25/8.
Ms. Ainungwa Leonard GA has submitted that this matter may be adjourned for the day on the ground that the Leonard Conducting Council is indisposed. On the appellant not objecting to the same, prayer is allowed. This is matter of the how long?
3 weeks, Your Lordship.
Why 3 weeks?
Early hearing, because he's inside, my lord.
2 weeks,
They
Your
were
Lordship.
inside.
2 weeks.
Similar order, Your Lordship, for item 3 and 4, or 4 and 5.
4 and
Your
5.
Lordship.
You are also here, Mr. Kinjing?
Yes, my lord.
4 and 5.
Same incident.
Oh, same order.
Yes.
Item number 6.
Obliged, Lordship. Your Lordship, this is the LSC matter, Your Lordship. LSC matter, Your Lordship.
Legal aid matter.
Yes.
For criminal
Who's the-
appeal.
who's the
Paper
counsel?
book is not ready.
Paperwork is here.
We have not
We
received
have
the
received
paper.
your no.
We have not received the. We have to ascertain.
Oh, you have not received.
We'll ascertain.
You
from
get
the
it from the registry. This is a legal aid matter, so
Yes, my lord, we'll find it.
Mr.
You can give us a copy.
S. Miss Leonard Counsel appearing on behalf of the Leonard Legal Aid Council has submitted that the paper book is ready. However, Mr. S. N. Gupta, Leonard Additional PP, has submitted that that copy of the paper book has not been received by the state respondent. Accordingly, the registry is directed to ensure that a copy of the paper book is handed over to the state respondent. On prayer made by the parties, this is matter of the history directed. I took the first line. Leonard Counsel, appearing on behalf of the has submitted that the paper book has been received by the appellant. The rest we will see.
We'll ascertain.
Obliged, Your Lordship.
This is matter of the 3 weeks.
I'll be obliged. Give us. Will you give you? Hmm?
Itu Johnson ta. Apa kila you receive ru.